Howdy, Facebook Live. Sean Yesner here. We're going to go behind the scenes to do a recording of the Crushing Debt podcast. I've got my good friend Dale Appell of the Appell Law Group. Welcome, Dale. Say hi to Facebook Live.
Hello, Facebook Live.
So this episode, these episodes, we're probably going to record more than one. They'll come out over the next couple weeks, probably as we get into July is when these episodes will hit. But enjoy the behind the scenes recording now. If you've got questions, leave them on Facebook Live. When we're done recording the podcast episodes and you have questions, we can maybe answer those questions, assuming they're not already going to be answered by the recording of the episode itself. So we've already got 4 people watching. So if you're ready.
Yes.
Okay, let's get this. Okay. On this week's episode of the Crushing Debt podcast, personal injury attorney Dale Appell. So welcome back to this week's episode of the Crushing Debt podcast. My name is Sean Yesner with Yesner Law, and as you heard, I have a guest on this week's episode. So I've known this attorney probably about 9 or 10 years now. He handles personal injury law here in Tampa Bay. He is a Duke Law grad from 1989. He's also a member of the multi-million-dollar Barrister Club. So what that means is that he's had jury verdicts or damage verdicts, I think, in excess of $1 million. He's had multi-million-dollar damage award verdicts, and he's done that multiple times. His website is wefightforjustice.com. And please welcome my guest, Dale Appell. Welcome, Dale.
Welcome. Good to be here.
So being a personal injury attorney, there's a lot of topics that come up, especially in my world of, a lot of times it's the personal injury itself that creates the deficit in income that leads them on the path to having to have trouble with creditors, file bankruptcy, do all that kind of stuff. So I thought it'd be a really good idea to have you on the show to talk about some of those things that could arise when you're facing a personal injury lawsuit or facing some type of damage from somebody else's negligence. So, and I know that we had a couple of questions come up here at the very beginning that you and I sort of kicked around in terms of content for the episode. So we're just going to sort of take them down in order. So I know that one of the questions that I get a lot is on the other side of the coin. So I've caused damage to somebody else. I was the cause of the car accident or something like that. So how would I protect my assets from you as the personal injury attorney coming after me for those damages?
Sean, that's a great question. And people have to be concerned about these things. I think sometimes people get overly concerned, but still it makes sense to protect yourself. And it's not that difficult to do. It really depends upon how big of a financial assets you have. The more financial assets you have, the more vulnerable you are. The first line of defense, though, is for you to make sure you have the appropriate insurance and insurances. And then you need to find what the right amount is. Nobody wants to overpay for insurance. That's just a bad idea and doesn't feel right when you're writing those checks. But then you don't want to be left with too little. So the first thing to do is to evaluate how much, for example, auto insurance you have. We're going to talk about premise liability insurance in a moment, homeowners insurance, but an auto accident is potentially the most significant way that you can have a judgment against you. So one thing to do is to make sure that you have some amount of bodily injury. No matter what your assets are, it's very important that you have at least $10,000 of bodily injury insurance on your auto insurance policy. It's not a requirement in Florida. You don't have to have that. And if you're looking to save money on your premiums, it's a good way to start. But what people don't know is why you don't have to have $10,000 or any bodily injury insurance, which protects you in the event that you injure somebody and cause them to have a wage loss or have them incur medical bills, or if they have a permanent injury in Florida, money for pain and suffering. You don't have to have that insurance, but we have a financial responsibility law. If you don't have at least $10,000 in bodily injury, you injure somebody and they get a judgment against you, they can take your license away for up to 20 years until you pay that judgment. that will really wipe out your financial assets.
Yeah, and I've dealt with that before. I've dealt with that a lot on the other end, the client that doesn't have the bodily injury that a coverage, and then they injure somebody in a car accident, and then they come to me and say, hey, I can't drive anymore. My license has been suspended. I can't drive anymore. And then we have to contact a personal injury attorney and settle with them. Or in a worst case scenario, that could be a situation on the other end where bankruptcy comes into play to eliminate the obligation to then allow the driver to get their driver's license back. But now you're filing bankruptcy. If you're a high wage earner, that causes issues. If you have assets that are not exempt, that causes issues. So it's really something we got to be careful of. And for the little bit of money that it probably costs to get bodily injury is probably a good idea.
Yes, absolutely, Sean. And so even if you have zero in the bank, make sure that you have at least $10,000 minimum bodily injury insurance, and then you don't have to worry, at least with regard to losing your license as a result of causing an injury to somebody else in a car. The next thing to do is to try to figure out the appropriate amount of insurance to have. And I say that you should have about as much in terms of insurance bodily injury coverage as you have assets. So take a look about what your net assets are, and then increase the amount of insurance you have to approximately that amount. And what that does is if you're in an accident that caused significant injury, a personal injury attorney like me is going to have a choice. Do they want to take the amount of money that the insurance company is offering or in exchange for a release, or do they want to come after your assets and pursue you personally? Well, nobody wants to take the time to go after somebody personally. They may force them into bankruptcy. They may spend the assets before you get the judgment. They prefer the insurance, but the insurance has to be there so they can advise their client. So get as much bodily injury insurance as you have in assets. And then as your assets grow over time, just make sure you reevaluate and say, do I need more insurance? So what you don't want to have is a low level of bodily injury insurance and a high amount of assets. That makes you vulnerable. And then as you go up in terms of bodily injury coverage, you'll find the expenses is a lot less. Because let's say you have $100,000 of insurance and it costs you a certain amount of money. By the time you get into $500,000 or $750,000 or $1 million, the cost goes up very slowly because there's a lot less $1 million cases that occur.
Right. It's not an incremental increase.
Right.
So it's going to cost you less for that additional coverage.
Yes.
Okay.
And at some point, if you have a certain amount of assets, you can then get an umbrella policy. Once you kind of max out at a certain amount, you can buy a rather inexpensive umbrella policy. That may be $1 million or $2 million. That would cover a large amount of assets and covers you even for things such as potentially, depending on your contract, defamation suits, premise liability at home. If you're in a watercraft and you cause an injury or accident, it can cover you there. So an umbrella policy, depending upon, again, your financial resources, may be appropriate. So look at your homeowner's policy. Make sure you're protected in the event that you have somebody that's injured in your home. Look for certain exclusions. You don't have to read that whole policy. They're 30 pages long and they're very small print, so who wants to read it? But look for the exclusion. So one of the things that we find is that sometimes people will have animals in their house, dogs, for example, and the dogs may actually, you may have a wonderful dog, you love Fido, but he can escape, or sometimes he'll do something irrational. I just had a case like this the other day where the person had the rider and they had assets. And so we got a money judgment directly from them because we could have sued them and potentially from a jury verdict gotten a lot more money. And so make sure that either if you have the exclusion, that you either get a separate rider or that you might consider having a cat instead of a dog. I mean, those are kinds of things that you might consider. But insurance is a wonderful first defense. And then after that, there's some other things that you can do that we can talk about. So, for example, trusts are a great way to protect any individual rental property that you have. Your IRAs, your retirement funds are generally protected from the claims of creditors like a personal injury attorney. But you may have rental properties that are exposed. And so you could be spending a whole lifetime building a portfolio of real estate, and all of a sudden a large judgment comes in from a firm like ours, a personal injury law firm, and then you've got a problem. you can't just dispose of those rental properties easily in anticipation of my getting a judgment against you. But there's a very simple way to solve the issue. And that's one of the reasons why I'm a big believer of, looking from this side at people that we might pursue and considering land trust. I think it's a great way to protect your individual properties. And that way, if there's a lawsuit, one, when I'm looking at your financials, when I do a public record search with a trust that's named in somebody else's name, with not you as a trustee, but somebody else, you won't appear vulnerable to a claim from me or from anybody else for that matter. So land trust, I think, is a great way to kind of shield yourself from public access, which is increasingly out there, very easy to find, and actually will help to prevent lawsuits against you. When we don't see a significant amount of assets, we tend to accept the insurance policy that you have, or may decide and tell our client, this person's not collectible. The other thing is, let's say you have a rental property and that particular renter has a dog on the property, and you didn't know that. They bring the dog and the dog hurt somebody. And the person that they hurt says, oh my gosh, I got this terrible scarring and I've had all these medical bills. I'm going to need plastic surgery and I'm suing you because you're the landlord and the dog was on your property even though the renter brought it in, and your insurance has an exclusion. If that property is in its own land trust, I can only go after that land trust and the asset within that trust. So at least you're limited. So you may have 100 different properties, but I can only pursue a claim against that trustee because that's considered to be an individual or corporation that owns that single asset. So you've then isolated the claims that may come against you. So I think a land trust is a great way to hold assets. Rental property.
I agree, and that's how I advise a lot of my clients that invest in real estate. Is either let's put them in land trusts, let's put them in LLCs, let's put them in some combination where maybe the LLC is the trustee and they are the beneficiaries, and there's all different types of complicated setups. I like to keep it simple, but there's all different kinds of setups we can do. And it's interesting because when I introduced you, when I gave everyone your biography, it was as a personal injury attorney, but I know from experience, you're not necessarily a real estate attorney like I am. You don't necessarily practice real estate law like I do, but you do know a lot about real estate law and about real estate investing. And so everything that Dale said, I think I agree with, 100% with everything in terms of sheltering assets. Do you really go after, for example, if you knew that somebody you were suing for causing an accident, let's say you knew that they had an expensive watch, is that something you would really try to pursue if you thought that it had value to it? Are you going after cars that are free and clear? I guess the answer is you're looking at all that stuff, you're giving your client all the information, you're interacting with your client, you're letting them make the decision. But is it really something where you say, hey, you've got a Rolex, I'm going to go after it? Or, hey, you've got a $4,000 car that's free and clear, I'm going to go after it? Are you really looking at that kind of stuff?
A little differently. We work on contingency. As personal injury attorneys, we get a percentage of a settlement verdict. So we only get paid if money comes in. So we have to look at the case and decide, are we going to make enough money and to get a judgment against these folks? And we're not going to go after a Rolex watch. But if you can afford a Rolex watch, we're going to have a heightened interest in finding out whether or not you have assets. So,
right.
We're going to we're going to see where you live. We're going to see if you maybe live on the beach or you live in a nice home. If it seems like you have a stable job and income. So we're going to be looking for those telltale signs. Normally, people that have any kind of meaningful asset or any kind of assets, really, it's so cheap to get auto insurance. So we generally don't find that people with some assets don't at least have the minimum or some amount of bodily injury insurance. But what does happen sometimes, and this is where it can get difficult to protect yourself, is there's a mishap. Maybe somebody forgot to pay their auto insurance bill. You're out of the country or something, and you missed a premium and the policy lapsed. Or that there's some type of exception or something that occurs with the insurance company. And sometimes it's kind of sneaky. They say, we're out of this. We're not going to be involved because you didn't follow the policy language in page 95 and this one word that's an exception. For example, we're now fighting, and we've actually sued a commercial business that had a trailer attached to the truck. And they had insurance for years with a well-known tiered company, and it was a 12-foot trailer. Well, they switched to a 16-foot trailer, and they had a broker. So the broker, could have been aware of this, could have advised them. And so the person did everything possible. Went over to his insurance broker and says, well, just so you know, I have a 16-foot, no longer a 12-foot trailer. And the broker said, okay, well, we'll submit that. And they have the VIN number and all those kinds of things. And now the insurance company is coming back and saying, on that page 37, it says we're not going to insure anything over 12 feet. And so the person's saying, well, I did everything possible. I protected myself. Well, you didn't read page 37 where it said 12 foot, did you? Wow. So now we're actually suing the company, and, it's a sizable enough company. He has no interest in having a judgment against him and no interest in having to file bankruptcy. And all of a sudden, because this insurance company found this exception, they're trying to get out of it. And we're in this big lawsuit right now to determine if they can. And we're actually on the side of the company and trying to make sure that they're providing insurance. We may win or lose that particular, what they call deck action. So, those are the kinds of situations where it makes sense to protect yourself, even if you have insurance. And again, assuming that you have some assets. So asset protection, it's something that you should talk to an attorney about. You can find some information online, certainly, but it makes sense to put all of that in place. The insurance protection, make sure you have the right amounts, also considering to hide yourself from public view through different corporations and trusts, as well as thinking ahead, because even if you have that first barrier of insurance protection, you may find yourself in a situation that you're either without the insurance protection, or the insurance company that you thought was your friend is now unfortunately your enemy.
So it's interesting. We're also recording on Facebook Live as we record the podcast episode, and we had a question come in on Facebook Live. So Celeste is asking, I lost it. Let me find Celeste's question here. But in the meantime, while I find Celeste's question again, why don't we go on to the next question that we have for you, which is, I was just in an auto accident. What do I do next?
Well, of course, the first thing to do is to call for help for 911 and get medical attention if you need it. So given that, the next step, of course, would be to call the police. And I say that because it may seem obvious to some, but when you're in an accident and you're not at fault, the person who is at fault may run over to you and say, don't call the police. Let's just resolve this. Let's just settle this between ourselves. I'll give you my insurance information and so forth. And they say, oh, something, I want to be a nice person. And that can cause a problem. Being nice is a wonderful thing. I recommend it to everybody. But in a situation like that, don't be so nice. People who may come over and say, I know I'm at fault. I did this, and I just want to give you my insurance information. I'm going to move on to a meeting. I got to move on with my day. Let's just have our insurance companies resolve this matter. I got plenty of insurance. Great. But calling the police can become very important, because later on, that person may change their story completely. And I've seen it happen too often. People may take immediate responsibility and then say, something, I don't want to be held responsible for anything I did in terms of property damage or injury. So I'm going to change my story. People do lie.
Or I don't want my insurance rates to go up. So I'm going to think of a version of this story where I'm not at fault, so my insurance rates won't go up.
Absolutely. And it is such unfortunate, because very nice and kind people get themselves into trouble by being kind in a situation like that. If the police come out, it does a couple things for you. One, the person who is at fault will likely get a ticket for whatever they're at fault for. Less likely then to come back and tell their insurance company committing fraud that they're not at fault, because the police ticket is right there in the accident report.
Although, and I don't mean to interrupt,
Sure.
but my understanding is that the ticket is not evidence, or cannot be evidence, in the personal injury lawsuit. Is that correct?
It's absolutely correct. There is a accident exemption, evidence exemption. And the reason why is the state of Florida, you may agree with this or not, says that if there's an accident, it's very important for the police to be told the truth about what's going on, what happened in the accident, so they can report to the Department of Transportation, who reviews all these accident reports to figure out whether an intersection needs to be changed or maybe the speed needs to be lowered. So for the good of the state, for the good of society, whatever you tell the police officer is not going to be part of evidence. In addition, you can't tell a jury in a litigation auto accident case that there was a ticket written, because a ticket is a criminal matter. The criminal courts, generally it's in front of a judge, it's a simple thing, but still it's a criminal infraction. So that's decided by them, by the judge. So the jury can't hear about that in a civil suit. They have to make their own decisions about who's at fault for the accident. So that the ticket will never come in. The fact that the police were called out will never come in. What is said to the police will never come into evidence. But here's the benefit of calling the police. You're less likely to get to need a jury verdict or litigation if the police are called out. One, because the insurance company is going to say, there's a ticket here. Maybe our insured is saying something a little different than what's in the accident report. But there's enough evidence here that we're just going to process this claim and move forward and provide the insurance coverages. If they hear from their insurance, they're insured, that the accident didn't occur as you said, then they may say, we're going to fight this thing tooth and nail. We don't have a police report. We have no evidence about what happened here. And we have our insured saying that they're not at fault. So let's fight this thing. That's not good for the insured, because the insured now is not going to gain the protection of insurance, but it may force there to be a need for litigation when one would not be necessary. The other thing that happens is that when the police come out, they're going to do an investigation. As we just said, the traffic ticket is not admissible as evidence, nor is whatever is said to the police officer. But what is admissible is the information that the police gather at the scene. So if the police are out there saying, that person who's at fault is telling me one story, and the person who has called us is telling us another story, well, let's measure how far the vehicle stopped before came to rest after the impact. Let's take a look at the damages. Let's see about skid marks. Let's get any witnesses on this police report before they disappear, and let's figure out what's going on here. So you could do that investigation yourself and try to come up with those things, but having a police officer do that kind of investigation is even better. So while he can't come in and say, here is the ticket, I gave them a ticket, they're at fault for this, they can use the accident report to refresh their memory at trial. So their testimony then can be based upon, well, yeah, I measured the skid mark, I looked at the property damage. You can't say, I know that the other party's at fault, but that information can be really helpful at trial. And again, just having the police report is going to help prevent the need for a jury trial.
Okay. So I want to take a step back. So earlier I mentioned Facebook Live. We had a question from Celeste, and Celeste's question is cash value in a life contract, I assume she means a life insurance contract, vulnerable in an at-fault auto accident? So if there's cash value in her life insurance policy, is that an asset that you can pursue to satisfy a personal injury judgment? I think the answer is no. I think there is a specific exemption under Florida law for the cash value of a life insurance contract, but do you agree or disagree?
I agree with that. I would have to review the statute to see if anything's changed, but I do believe the law protects life insurance cash value in addition to things like annuities and IRAs and 401ks. I think it falls under that umbrella. They're trying to give protection to people that's why Florida is considered to be a debtor state. So, there's certain things that you can do in Florida that protect from claims of creditors. They're not always going to work. It's not always complete protection, but like a home, for example, is a wonderful place to have cash value and equity because it's free from the claims of creditors, because we have homestead protection here in Florida. And I think the same thing is true of a cash value life insurance.
Yeah. Okay, cool. So I think we are getting pretty close to the end of our time for this episode, but I've learned so much in the last however many minutes we've been recording. We're going to have Dale back for another episode. So is there anything, Dale, that we didn't cover that maybe couldn't go in a future episode. Is there anything else that we missed? Anything else that you wanted to talk about?
Well, the only other thing I'd mention about if you're in an accident is if you go to the hospital, that you should make sure that all your injuries are documented. Usually emergency rooms are skilled at helping when there's an emergency situation. But if you have a pain here and there, it can get lost in the rush to treat the triage cases. But that documentation is really important later on. And if you don't go to the emergency room, be sure to see a doctor soon after the accident. People sometimes will say, especially guys, they'll say, we're going to rough this out and I'm hoping I'm going to feel better. And it may be true, but having documentation that the injuries that you're suffering occurred soon after the accident can, again, help prevent a prolonged contracted litigation process. And it's good to have. You may not ever need it, but it's good to have. So that would be one other thing I'd like to add.
Yeah, and I agree with that. I mean, a lot of times because we're dealing with, and again, I do not do personal injury law. I just know a handful of the terms, but because we're dealing with the types of injuries we're dealing with, some of those pains, aches and pains may not even manifest until a day or two or so after the accident itself. Plus, it is Florida law that you now have to get checked out by a doctor if you want to preserve some of your rights within the personal injury lawsuit, correct?
Sean, it's true. Back in 2013, a new law was passed and signed by the governor that restricts personal injury protection, or what's called PIP insurance. And so unless you have an emergency medical condition, for example, you only receive $2,500 of your medical bills paid versus $10,000. And as you were suggesting, if you don't get treatment by a doctor and ring of the bell for medical treatment from an auto accident within 14 days, so that's a good amount of time. But still, some people are trying to, they don't like to see the doctor. They don't want to get any treatment. I'm
just going to take Advil and wait it out.
It's true, and they lose that $10,000 in PIP benefits. So if you don't use it within 14 days, you will lose it in Florida now.
Wow. Well, I do want to thank you for being a guest on this week's episode of the podcast. Again, Dale Appell, wefightforjustice.com, or you can email Dale directly, dappell, APPELL, at wefightforjustice.com. Dale, thank you for being on this week's episode.
Sean, it's been a pleasure.
And we will look forward to talking to you in next week's episode of the Crushing Debt podcast. Okay, so hang on, Facebook Live. I'm going to record this episode, and then we'll jump into another one pretty quick. But let me make sure I get this episode recorded before I start another one. So unless Dale wants to talk to Facebook Live while I do some stuff here on the computer, maybe you could talk about, let's see, what could we talk about to Facebook Live? Maybe what is personal injury protection? So we left off with the podcast recording about PIP, personal injury protection. So what does PIP cover? What does personal injury protection cover?
Great. I appreciate that question. It's an important one because people don't realize oftentimes until they actually need it, what this PIP insurance is about, how it works, why they're paying for it. In Florida, we are in a no-fault state. And that means that each individual that drives a vehicle has to carry PIP insurance to pay for their initial medical bills from a personal injury, whether they were at fault for the accident, whether they weren't at fault, whether they were a passenger, even if they were hit by a vehicle and they were walking across the street. PIP, personal injury protection, comes into play. So as we just were talking about in the previous episode, the PIP insurance has to be used within 14 days. And you can see through that PIP insurance any medical provider you want. You can go to the emergency room, although sometimes I don't recommend emergency rooms because I guess most people may realize that they're there to handle emergencies, triage situations, broken bones, bleeding, and those kinds of things. So don't hesitate if you need to go to the emergency room, but sometimes they're not as thorough and they're not as appropriate depending upon the injuries that you're experiencing. But do get to a doctor or medical provider soon after. That's paid for by PIP insurance. The other thing is that if you're in an auto accident, you may not be able to go into work for a certain period of time, maybe even a long period of time. PIP was designed to give you immediate reimbursement of your wage loss. Usually it's about 60% reimbursement rate. It's in the contract that you have. You'll need to get a disability statement from the doctor. You get a wage verification form to your employer, and then you submit it to the insurance company. And as long as there is PIP remaining in the envelope, again, it could be $2,500 up to $10,000, you can get immediately reimbursed for your wage losses. And that could be really significant, particularly if you're living close to paycheck by paycheck. So very important thing to consider. It's also important to consider that if you go to the emergency room, you need to lock up a certain portion of your PIP for wages. So for example, if you go to the emergency room, let's say you go to the doctor the next day, or they recommend an MRI the next day, you may use up that $10,000 in PIP, so that when you submit your wage reimbursement, the adjuster says there's no more money in the envelope. So it's important, and you have the right to do this, to reserve a certain portion of your money for wage reimbursement. So some go to medical bills, some are wage reimbursement. Even if you think you're going to need the wage reimbursement, it makes sense to reserve that money. You could always let it go in the future. You could always say, yeah, I use that money for the medical bills. I don't have to use it for wage reimbursement anymore. But if you don't lock it up, you could lose it, and that can really cause a financial burden on you. So make sure you do that. And the other thing that PIP can be used for is mileage reimbursement. If there's prescription medication that you pay for, all of those things are provided for reimbursement through your PIP insurance. PIP has a deductible. So generally it's about $1,000. So if you go by ambulance to the hospital, you're going to get a bill from that ambulance company for the ride. When you go to the emergency room, you're going to get a bill because they're going to submit the bill to your insurance company, your PIP adjuster, and he's going to say, wait, there's $1,000 deductible. Send the bill to the person who's injured. Also, PIP only pays 80%. So there's a 20% bill outstanding. So there's a couple things you can do about all this. One is that you could buy something that, in addition to PIP, is called medical payments or MedPay. And what that's designed to do is give you some additional PIP coverage, but also pay for any deductibles or co-pays that are out of your pocket. And the other thing that you can do, if you don't want to buy MedPay or in addition to, is buy uninsured or underinsured motorist coverage, or UM for short. If you buy that insurance from your own insurance company, it doesn't matter if the person who's at fault is carrying bodily injury insurance. You know that your insurance company is going to, in essence, step into the shoes of the at-fault party and pay for things such as wage losses that are not reimbursed by PIP, medical bills such as the co-pays and so forth that we talked about that are not paid for by PIP, and finally, if there's a permanent injury, money for pain and suffering. So PIP is something that everybody has. Medical payments and uninsured motorist is optional. Particularly in Florida, I think it's important to pay for the uninsured motorist coverage, and then you could decide whether it's appropriate and necessary for you to buy the medical payments.
Cool. So thank you for that, Dale. I have got the next episode ready to get queued up. So if you're ready to start on the next podcast episode, we can get started. Same thing as before. I'll do the intro, and then we'll launch into it. On this week's episode of the podcast, Dale Appell with WeFightForJustice.com. So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner. The podcast is sponsored by my firm, Yesner Law, but also this week it is sponsored by a returning guest, Dale Appell, with the law offices of Dale Appell and his website, WeFightForJustice.com. I introduced Dale in the first episode, but know that Dale is a personal injury attorney here in Tampa Bay. I've known Dale for about 9 or 10 years now. He has generated multiple multi-million-dollar verdicts for his clients. Those of you listening to this week's episode of the podcast, go to my Facebook page, which is just my personal page, Sean Yesner, on Facebook. And check out, I'm recording a Facebook Live of us recording the podcast episode. And so if you want to go check out the Facebook Live video, I'll do what I can to get it up on YouTube as well. Dale covered a topic that is not going to be covered in either of the two Crushing Debt podcast episodes, the one we're recording now, the one we recorded earlier. The topic that Dale just talked about regarding personal injury protection or PIP coverage is not going to be covered in one of the two podcasts. So if you want to hear about that topic, go to my Facebook page. I'm sure I'll link it to Dale and to his firm's Facebook page. So go check out either of those sources if you want that additional content, something that we'll do for you here for checking out Facebook Live. But I want to welcome back Dale to this week's episode of the podcast. So welcome, Dale.
Thank you, Sean. Great to be here.
And what I thought we'd do is pick up on some questions. We had a couple of questions that we had sort of vetted prior to the recording of the episode. And so two of them were particularly interesting to me. So why don't we get into those two? The last two that you sent me that we talked about. So can a parent be held responsible for their kids' bad driving habits?
Great question. And important for parents to know. Kids can get into trouble. Recently in the Tampa Bay area, this was highlighted by that very unfortunate case on Bayshore Boulevard. A parent who happened to be a former executive at State Farm purchased for their newly graduating senior son from Tampa Catholic a brand new Mustang. I think it was a GTX. It was kind of a sports car for a young person, and they were drag racing on Bayshore Boulevard, where the posted speed limit is about, I think, 45. And I think they recently reduced it to 35 as a result of this incident. And they were traveling at 106 miles an hour, and a couple, actually a woman from out of state who was visiting with her baby in a stroller, got killed by the 18-year-old, I believe he was, drag racing on Bayshore Boulevard, a horrible incident. And so this question is particularly relevant right now in consideration of that. So certainly that kid who was making a bad judgment, bad decision, drag racing on Bayshore Boulevard, is going to face criminal penalties and issues. The person can also be held civilly responsible for the wrongful death of these two people, the mother and the baby. Now, whether the parents can be held responsible as well, that has a number of aspects to it. So one is, if they have title in the vehicle that caused the deaths, they certainly can be held responsible. That's true if they purchased the vehicle. It's also true because your child between 15 and 16, you have to sign something that says that you're taking responsibility for the actions of your child, even when they're training to get their license. So there's various levels there that make you responsible for the actions of your child. But they can also be held responsible in a little bit more esoteric way. If your child has a habit of drag racing, for example, and you give them this car that results in a injury or a fatality, you could be held responsible because you were grossly negligent in providing and entrusting this child with a vehicle that could be considered a weapon if driven fast and not paying attention to the rules of the road, and resulted in an injury. So you can also be held under the negligence statute as well as a parent.
Okay, so is that something, I know we talked about in the first episode, we talked about insurance. Is that something that my first step, if I'm the parent, would be to go to my insurance? But I have a feeling the insurance company is going to try to get out of coverage for that because of the nature of the accident, would be my guess.
It really depends on the insurance policy and the way that the insurance policy is written. It also would be determined in part by the insurance coverages. So if you added that vehicle to the policy, then the vehicle may be covered under your insurance. Or if your child is listed as a driver. Now, some parents, trying to be coy, may say, well, gosh, he's going to have a separate policy. And that way our insurance rates, we don't want them on our general policy. Maybe it'll be better or less expensive for us to have their own. And it may depend upon how old the child is, whether the child is 18 or 17. All of those kinds of things are considerations. But generally speaking, the insurance company may try to get out of it. And those are some of the things I just mentioned are some of the ways that they might look into the policy to try and do that. But normally the insurance company, other than the situations I mentioned, would take potentially ultimate responsibility. They might try these different things to get out of it. So be careful how you write the insurance policies. But otherwise, they would cover the gross negligence.
On my position, unfortunately, having dealt with insurance companies in different capacities, title insurance companies, E&O companies, that kind of stuff, my personal opinion, good, bad, or otherwise, and I apologize to all my insurance company friends, but insurance companies aren't going to make a profit by paying out claims. So my personal opinion is their first instinct is, how do we deny the claim? And then if they can't find a way to deny the claim, then they reluctantly say, okay, let's pick up coverage and run with it. But that's my personal opinion. I know there's probably some insurance companies out there that are great. There's insurance agents, there's insurance adjusters. I love everybody in the industry, but my personal opinion is the first thing they're going to do is try to deny coverage.
Yeah, make sure you protect yourself. And it's true whether it's a auto accident or a busted pipe at your home. You really, before you call the insurance company, really should understand the issues involved in asking the insurance company to take responsibility and providing you the insurance that you thought you were buying. So, with a homeowner's policy, as you know, there could be a huge difference on whether water came into your home or water came from a pipe or from the roof. And, there's certain exclusions and certain ways they've written the policies that may end up really being a problem for you. And it all may have to do with things that you said. And you may have said it inadvertently, but all of a sudden the insurance company says, you said that, we have a recording of it, and now we don't have to provide coverage. You say, well, that's not what I meant. That's not the point. That's what you said. So it's really important before you call the insurance company in any claim that maybe you speak to an attorney, have them review the coverages to find out what your legal rights are, or at least grab that policy that you threw into the file and thought you never hopefully would have to look at and review it carefully to make sure that your particular circumstances are covered. Very good idea. And as far as recorded statement, be very slow to give a recorded statement in insurance situations. So if you are involved in an accident, somebody else's fault, the at-fault party's insurance has no right at all to a recorded statement. No reason to give them a recorded statement, no benefit to you. They still have to adjust your property damage claim. They still have to consider any kind of personal injury claim. No reason, no benefit giving them a recorded statement. And they're going to ask. With your own insurance company, you do have to give them a recorded statement because you have to cooperate with them. That's part of the contract you have with them. But you don't have to give it immediately. So when you're hyped up, when you're not feeling well, right after the accident, you're intense, you're not thinking through all the issues, bad time to give a recorded statement. So feel free to say to your own insurance company, I'm going to give you a recorded statement. I look forward to cooperating with you, but just not today. It's not a good day. Let's do this next week. And at that point, you may have either hired an attorney or at least had an opportunity to consult with an attorney so you have an idea about what the issues might be before giving a recorded statement. And if you do give a recorded statement, we as a law firm always like to be on that call because when you speak into the recording, you use your voice inflection to express a lot of information. So when you record, it may sound like I'm telling them everything that's the truth. But when you transcribe and look into the black and white of what you said, your voice intonation isn't there. And you say, well, that's not what I meant. And then they say, well, that's what you said. It's here in the cold, hard transcript. So very important potentially to have a attorney on the phone to make sure that if they ever type up that recorded statement into a cold black and white transcript, that everything that's there is what you really meant to say.
Now, years ago, I was not involved in the accident, but I was a witness to a pretty bad car accident. And after I got home and was settled in and everything had calmed down, I actually took out a piece of paper and I wrote my memory of what happened in that car accident. And so I was thinking, on the one hand, do you think that's a good idea to preserve your own memories just to write it down? But on the other hand, is that evidence that could be discoverable by the insurance company, by the other side? In other words, if you write down your impressions of what happened during that accident, and then someone were to find out that you wrote down that statement, and then that statement potentially becomes inconsistent with your with your verbal statement, is that a good idea to write down, hey, here's what I remember happening so that I don't forget when I'm later questioned? Or is it a bad idea to be creating evidence, so to speak?
It's a great question, and there's a lot of things to think about with regard to it. One is preserving your memories is something that's important. The particular type of situation that you're describing, where you're taking notes, that is likely to be able to be kept out of evidence. That may be notes that you're taking in what's called anticipation of litigation, or maybe a result of something that your attorney asked you to do. And there's ways that we can keep that out. So I don't think that's necessarily a bad idea. I don't know how necessary it'll be. Generally, the facts of a case are pretty hard in your head, and you don't necessarily need to write it down, but it's something that you can do. And I think feel pretty comfortable that that's going to be protected and not used against you. Where it's a real problem in personal injury cases is where you say something at the hospital, or you say something, and so it's in the medical records at the hospital. And again, you're hyped up, your adrenaline is flowing, and you say something without really thinking, and all of a sudden later on you say, well, that's not really what I meant, or it wasn't like that. Well, it's in the cold, hard record, and that creates a problem. So, people think their social media is protected, for example, but the laws are now saying that even if you have your Facebook, for example, your page in privacy, so only your friends can see it, a defense attorney can get through to that. You have to provide them your passwords. You have to give them access to that. So that kind of information that's spread out in the world already, in the medical records or on Facebook and social media, or if you speak to your friends about an accident, your friends could potentially their depositions can be taken. And while anything that you and I discuss as my client is attorney-client privilege, that's not true with things that you say to your friends. So I think the personal notes, if you find it helpful and useful, I think that's the safe ground. It's all the other things, all the other forms of communication that I think you have to be really careful about and likely don't want to necessarily put into the record.
Okay. So last question that we went over that I was really curious about. So one of the questions you sent me, one of the topics you sent me, I got hurt at the Hard Rock Hotel. Now we all know, or maybe you don't know, the Hard Rock Hotel is owned by the Seminole tribe of Florida, which is one of the reasons that they get an exclusion to allow gambling on the property, blackjack and craps and the other table games and whatnot. So I wonder if I just have to label this episode explicit now because I said the word craps on the, I don't know, we'll see. So anyway, I got hurt at the Hard Rock Hotel. Can I sue the Seminole tribe of Florida?
The answer is that you can sue the Seminole tribe of Florida, but it is very unlikely that you're going to find somebody to take the case. And the reason for that is, as you mentioned, the Seminole tribe of Florida is considered to be a separate nation. That's the treaty that the various Indian groups have with the United States. We're within your country, but where we have property and reservations, we're considered to be a foreign type of entity. So you potentially pursue a claim against the Seminole tribe in federal courts, just like if you were injured in Paris, you could potentially use the courts to pursue a claim against Paris, but you really expect that you're going to be able to find a contingency fee attorney to spend all of that time pursuing the claim against a company that injured you in Paris. It's going to be extremely difficult. So Seminole tribe has a lot of protections. So it's possible, but oftentimes it's a matter you're going to have to deal directly with the Seminole tribe to try and get some type of resolution. And for publicity reasons, the Seminole tribe could potentially be reasonable, but just be aware that if you're injured at the Seminole tribe from what you think is negligence, the more information you can gather about what happened and why the Seminole tribe is at fault, the more likely you're going to be able to get a settlement that you think is appropriate for whatever the injury is. And just realize that trying to find an attorney and trying to pursue a claim against the Seminole tribe is going to be very, very difficult because they are considered to be a sovereign nation within our nation.
Well, and along those lines, and even maybe taking it more simple and even maybe a situation that could happen more likely than getting hurt at the Hard Rock, The way the courts work, personal injury liability is typically a state court issue. If it's two people that live in Tampa and there's a car accident, that case is probably going to be filed in state court in Hillsborough County in the courthouse in Tampa. Where federal jurisdiction lies is if it's either with, like you said, the Seminole tribe or a foreign country, but also federal jurisdiction would also lie if it's two people from two different states. So my question is, where would you file the lawsuit, state court or federal court, if it was, for example, you get a call from a client that says, hey, I am a resident and I live in Georgia, but I was here in Tampa on vacation and I was in an accident, in a car accident, and it was the other driver's fault. And that other driver does live here in Florida. So you've got a Florida driver, Tampa driver, causing an accident and injuring somebody that lives in Atlanta or Georgia. So now you've got two people in two different states that are in a dispute. Is that something you would still file in state court, or is that a situation where you might go into the federal courts to seek a resolution?
And Sean, just so you know, as a personal injury law firm, we really work hard to avoid federal court. Insurance companies love to get us into federal court, and they try all kinds of tactics to do that. But federal court is a much more conservative, much more restrained area for a personal injury law firm. Our discovery methods are restricted. The judges tend to come from large law firms. Oftentimes they may have in the past, either them or somebody else have represented insurance companies. It's just not a plaintiff-friendly place to be. So we do avoid federal court whenever possible in every situation. And we do fight against the insurance companies who try for various reasons to remove us from state court where we filed to federal court. The situation you describe is a little bit different, though. In that situation, wherever the accident occurred is where the lawsuit has to be filed. And the fact that the person you filed against lives in Georgia or Alaska or anywhere else is not a concern. So we would file in state court if the accident happened here and they injured a person, even if our client lived in Georgia, even if the at-fault person lived in Georgia, it would still be filed in state court.
Okay. I didn't realize that. So that's interesting. So,
but different, just so you know.
Yeah.
If it's a uninsured motorist situation. So let's say you're in Georgia and you come down here and you get into an accident with somebody in Florida that doesn't have bodily injury insurance or not enough, and you have to file a claim against your uninsured motorist carrier. Well, in that situation, the uninsured motorist carrier says, well, wait a minute, we're not located. Our headquarters is not in Florida. There's very few insurance companies that are headquartered in Florida. We're in Connecticut, in Hartford. You have to come up here and sue us because you're basing your claim on a contract dispute, because the contract says we're going to provide you uninsured motorists. And yeah, we step into the shoes of the at-fault party. That's what your uninsured motorist coverage is all about. But we're not stepping into his shoes in Florida. So if you want to sue us, you have to come up here or sue us in federal court. And that happens a lot. And there's things that we have to do that are very special that has evolved and changed, because this was never an issue before. And then eventually these insurance companies, they have some smart lawyers that work on their side for $1,200 an hour. They figured out, well, we should get these guys to federal court. What can we do? And so in the last couple of years, we've seen them do that, where we file against the uninsured motorist coverage because the accident happened here, allows us to do that. And then they try to move us to federal court. And then what we have to do is work hard to remand the case, to bring it back to state court. And that's a fight. And there's certain things that we do in our demand processes to try to minimize that. But they have been effective in the past in getting us to federal court when you would think it would be a state court matter.
Wow. Interesting. So the first episode we ran pretty long with Dale, but it was all fantastic information. It was all tremendous information. If you're listening to this episode, I definitely suggest you go back and listen to the first episode we recorded with Dale. This one I'm going to keep a little bit shorter. So is there anything else that you wanted to cover? Anything else that we didn't talk about or didn't mention?
No, not today.
Okay. Well, thank you again for being a guest on this week's episode of the podcast. I'm actually running out of time. I probably need to get to a hearing for one of my clients. So again, you can reach Dale at wefightforjustice.com. Or you can email him at Appell, APPELL, PPL, at wefightforjustice.com. Or
I was going to say, feel free to call me. The phone number is 813-877-DALE. That's 877-3253. Or from Pinellas County, 727-866-DALE.
there you go. So you got Dale in the phone number. That's pretty cool. I don't think Yesner would fit. Or maybe it would, but I don't know what I'd have to pay for a number like that. So I'm going to leave my number alone for now. But thanks again for being a guest on both episodes of the podcast. And we will talk to you in next week's episode of the Crushing Debt podcast. Wow. So I said that one was a shorter episode, but it was a shorter episode by like a minute or two.
Okay.
Wow. So that was really good. Thank you. So we're still on Facebook Live. I don't see any other questions from Facebook Live. We answered Celeste's question. So Celeste, if you're still watching, it doesn't look like we have anybody watching. So I'm going to stop Facebook Live for now. That'll go up. I think I can figure out how to get it up on YouTube. I'll figure that out as well. Thank you again. If you want to say goodbye, goodbye, Facebook Live. I'll let you know next time we have a guest in the office to video behind the scenes of the recording of the Crushing Debt podcast. Thank you again to Dale Appell. You've got all of his information. I tagged him in the post as well. And we'll see you next time.
Thank you, Sean.
Wow, that was an hour-long video.
That was